So I stand in support of this bill. This bill relates to proposed amendments to the Supreme Court of Judicature Act. It deals with matters relating to the operation and jurisdiction of the Singapore International Commercial Court, or SICC. The SICC was officially launched in 2015. The idea behind it was to grow the legal service sector and to internationalize and export Singapore law. Since its launch, we have seen several cases go through the SICC, and it is important that legislation be updated to promote its efficiency. Similar to the point that Mr. Murali had made, I would like to ask if Minister can confirm the rationale for removing the pre-action certificate, and also whether there will be alternative procedures in place available to parties to now obtain early determination on these jurisdictional issues. Next, the other primary amendment that the bill seeks to pass relates to Section 18D of the Act, which deals with the jurisdiction of the SICC. It is in this context that I seek certain clarification. As currently formulated under Section 18 of the Act, the SICC has jurisdiction to hear and try actions that satisfy all of the following conditions. A, the action is international and commercial in nature. B, the action is one that the High Court may hear and try in its original civil jurisdiction. And C, the action satisfies such other conditions as the rules of court may prescribe. Clause 2 of the bill seeks, among other things, to introduce the following subsection to Section 18D. I quote, without limiting subsection 1, the Singapore International Commercial Court, being a division of the High Court, has jurisdiction to hear any proceedings relating to international commercial arbitration that the High Court may hear and that satisfy such conditions as the rule of court may prescribe. End of quote. Within the context of the international commercial arbitrations, recourse to the High Court is available under the International Arbitration Act, or the IAA. Given that such recourse to the High Court is already provided for in the IAA, and Section 18 of the Act already provides that the SICC has jurisdiction where the High Court has jurisdiction, why is there a need for this amendment? I note from the explanatory statement of the bill that the amendments sought are to, amongst other things, quote, provide for clarity that SICC has jurisdiction to hear any proceedings relating to international commercial arbitration that the High Court may hear, end of quote. But is this necessary given the current language of Section 18D of the Act? My concern is that the proposed amendments may be interpreted as conferring additional jurisdiction to the SICC when this is not the intention. Can it be clarified that this amendment does not seek to confer additional jurisdiction, but simply to clarify the jurisdiction that the SICC already has? If so, to avoid misinterpretation of intent, can I suggest that the following language be adopted instead? Quote, for the avoidance of doubt, the Singapore International Commercial Court, being a division of the High Court, has jurisdiction under subsection 1 to hear any proceedings relating to international commercial arbitration that the High Court may hear and that satisfy such conditions as the rule of court may prescribe. End of quote. Next, Clause 4B of the bill seeks to delete Section 82A(c) of the Act and substituting it with the following, quote, to prescribe for the purpose of Section 18D(2) what constitutes an international commercial arbitration and any conditions that any proceedings must satisfy before that court may hear those proceedings. End of quote. Essentially, within the context of Section 82A of the Act, if the amendment is passed, rules of court may be made to define what an international commercial arbitration is for the purpose of the proposed Section 18D(2). The IAA already has several references to the term international commercial arbitration. I think it's fairly clear what an arbitration is, and Section 5(2) of the IAA sets out what an arbitration is international. Finally, when it comes to defining the term commercial, the footnote of Article 1(1) of the first schedule of the IAA mandates a wide interpretation and provides guidance as to what amounts to relationship of a commercial nature. Given the approach that has been adopted in primary legislation, is there a need for the current amendments whereby rules of court may be made to set out what may constitute an international commercial arbitration? Is there a possibility that such rules of court may adopt a separate definition and create difficulty with the approach taken in the IAA? So notwithstanding the above clarifications, I stand in support of this bill.